today is that there's a decided slant in making partnership a viable, active, business-like arrangement, perhaps not quite as theoretical as a partnerships course would be in another context. I hope that you'll take advantage of the group, even though the room is rather large. The number of registrants here makes it possible that you'll ask questions, and I hope you'll take advantage of that. Don't worry about the formality of writing down questions, because that tends to kind of bog things down. If you do have a question of any of the speakers, there'll be opportunity throughout the day, throughout the morning, to ask the questions, and I'm springing this on Bob, but I'm sure you won't mind. Make this your opportunity to ask questions. Let's turn it into as much of a discussion as we can. The other thing I'd ask is that we have gone to a half-day format, and I think in future in many of these programs, a half-day format has distinct advantages over a full-day format, because it does allow you to get here at a reasonable hour and also get on with your life's business. I'd be interested in your comments about that, and I'd ask at the end if you take a couple minutes and fill out the evaluation form and let me know what you think. I'm Deputy Director of Education, and I worry about CLE on a day-to-day basis, so it's important to me that I do get your feedback. But as I say, I like the idea of a half day. I like the idea of a small group so that you do have the chance to ask questions. So take advantage of all those things. Now, our chairman today is Bob Milnes, who's seated to my right. Bob is a partner at Smith Lyons. He's a graduate of McGill University and Queen's and Osgoode Hall, of course. He was called to the bar in 1971. He's past chairman of the Business Law Section of the Canadian Bar Association, past chairman of the National Business Law Section of the Canadian Bar Association, and very well known to us at CLE, both at the Law Society and the Canadian Bar, for a number of his educational endeavors. Bob, it's a pleasure to have you, and turn the proceedings over to you.
Thank you very much, Joel. We have planned on 2 question periods during the morning, one at mid-morning just after the coffee break, and I would suggest, with all respect to Joel, we might stick to that format because the first 3 programs or 30 speakers do have an integrated topic, and your questions will probably be better if you listen to all 3 of us. The other speakers today will deal with the important attributes of running a law partnership, such as management, marketing, tax attributes, and in the case of Nancy Spies, what happens when it doesn't work out, and dissolution. I'm going to look at the formation of law partnerships and review the steps to be taken and the issues to be considered on the formation of a partnership. In my view, if these steps are taken and these issues are properly considered at the outset, future difficulties will in all likelihood be avoided. But first, a few general comments. There's no doubt that law partnerships are growing, and the reasons are obvious. We all know them. First of all, there are the increasing capital expenses required to run a modern law practice. Secondly, there's the increasing complexity of law. It's hard enough for all of us to keep up with our particular areas, and it's probably even harder for the generalist sole practitioner to cope with the exploding developments in various areas. There are many alternatives open to lawyers today: employment with government, employment with corporations. For those individuals who wish to retain their independence and remain as sole practitioners, cost-sharing arrangements or counsel arrangements. Notwithstanding these other alternatives, law partnerships are growing, and there's another factor which is hard to define, but in my paper I've referred to it as collegiality. And what I mean by that is that in most law partnerships, partners will support their partners through personal and professional misfortunes. It also a partnership provides a common front to the world in this increasingly difficult environment in which we're expected to practice. However, although partnerships are here to stay and are growing in number, most lawyers enter into partnerships with very little forethought and attention to the issues. And in fact, if our clients attempted to enter into the same kind of professional or personal relationships with the same lack of forethought, planning, and review, we would argue strenuously against it. I'd like to now consider 3 different situations. First of all, the formation of a new partnership. Secondly, a senior or experienced lawyer joining an existing partnership. And thirdly, the situation of an associate joining the partnership that employs him. First of all, dealing with a new partnership. Each new partnership is based on unique personal and financial factors. And basically, the partners must have a common philosophy on certain important areas, such as capital expenditures, growth of the partnership. In my view, it's essential that on the formation of a new partnership, the partners have a written partnership agreement. Several reasons for this. First of all, it serves as a checklist for important issues to be discussed, and in my experience, the preparation and negotiation of a written partnership agreement brings to light differing philosophies, and either these will be resolved amicably in some manner, or if not, the partnership will not survive. And if they don't come out in the negotiation stage, they may come out later to the detriment of the partnership. The partnership agreement also has an important role in the ongoing existence and preservation of the partnership. As all of you know, in a successful law partnership, the written partnership agreement is rarely consulted. However, it is always there in the background as to provide a final binding resolution of disputes should they not be solved by consensus, or if the worst happens and the partnership is dissolved, to provide an orderly method of dissolution of the partnership. And Nancy Spies later this morning will indicate the real difficulties that arise when a partnership does not have an agreement. The partnership agreement is also important in terms of clarifying the tax attributes of the partnership to evidence a course of conduct for the benefit of the Department of National Revenue. There's always an issue as to whether or not the prospective partners should retain separate counsel to draft the partnership agreement. Any lawyer worth his salt can draft a simple partnership agreement, but often outside counsel has an important role in providing suggestions on methods of resolving disputes or framework for the partnership. In some cases, there may even be an advantage for the individual partners to retain separate counsel. And in my paper, I give two simple examples. In the case of a very young lawyer entering into partnership with a senior lawyer who's been in practice for many years, the younger lawyer may want specific representations and warranties as to the conduct of the practice before the junior lawyer, before that practice is merged into a partnership. And therefore, he would want outside counsel to review these representations and warranties on his behalf. Equally important, from the point of view of the senior lawyer, he may want his own counsel to review the retirement and payout provisions to make sure that they are airtight and technical arguments or reasons will not be used to circumvent them, because like most of us, presumably his retirement income will be based on those provisions. If none of the prospective partners are family law experts, if no other experts are retained, I strongly recommend that partners forming a new partnership retain family law experts. As you're all aware, under the Family Law Act, the question of whether or not a spouse has a right to a part ownership in a license to practice law or some ownership right in a partnership interest is unclear. And presumably that's going to continue to wend its way through the courts. However, there are some basic steps, I'm told by family law experts, that can be taken at the outset. If only having one partner provide an indemnity to his or her other partners for any loss, damage caused by a matrimonial dispute involving that partner. I suppose it's possible in the early stages with a young with a group of young partners to have the spouses waive any interest in the partnership after having received independent advice. There's another important factor in terms of family law, and that is disclosure of partnership financial information. There is always a risk when a marital dispute erupts involving a partner that the firm's financial records will become part of the public record in the local courthouse. And I understand that there are several cases or motions now in progress where an attempt is being made to stop this kind of disclosure, and I'm told that it may be possible in a partnership agreement to provide some kind of way of circumventing that. I also strongly recommend that the new partners retain a firm of chartered accountants to advise them at the outset. The accountants have two important roles. First of all, the valuation of the separate practices being merged into the partnership. As lawyers, we all have an overblown view of the value of our respective practices, and it often takes a dispassionate outside observer or outside professional to bring us back to reality. The other role, equally if not more important, is providing the new partners with advice on the current tax situation, for example, the use of management companies for income splitting and so on. These rules are constantly changing, and Bill Strain will address these issues later this morning. I've attached to my paper the Canadian Bar Association's Model Partnership Agreement. It was prepared in 1979. It's still basically a good starting point, and there's also a checklist prepared by another committee of the CBA, which is a useful checklist for partners negotiating or settling a new partnership agreement. I'd now like to look more briefly at the situation of an established lawyer joining an existing partnership. First of all, he or she should review a copy of the partnership agreement. And if the partnership has no agreement, and many of them still don't, he should ask why and perhaps suggest that his entry into the partnership forms a good occasion for the partnership to prepare one. He should review financial statements of the partnership going back several years, and if he has no particular expertise in this area, he should consider retaining outside advice, chartered accountants, to help him. He should ask to meet all or a majority of the, really should ask to meet all of his new partners. And if there is some resistance to him meeting one or more of the existing partnership, that will either usually indicate internal dissension within the partnership that may erupt later, or even dissension in the partnership arising from his omission, which is another danger sign. He should also review the underlying philosophies of the partnership, either as reflected in the partnership agreement or as discussed with the partners, to make sure that they accord with his views. For example, if the lawyer joining the partnership believes strongly in a system of remuneration based only on gross billings, and the partnership has a more flexible system that provides remuneration for non-billable activities such as marketing or firm management, there may be a difference in philosophies there which could lead to trouble later down the road. In some cases, existing partnerships are reluctant to open their books and client records to a new partner with the fear that if negotiations break down, that the prospective partner will have good insight into the particular partnership's client base and so on. And I have seen this particularly in smaller centers. This problem or concern can be finessed somewhat by the use of a confidentiality agreement, and I've attached to the materials a sample that could be used in these situations. I'm not even sure these days that a confidentiality agreement is needed in view of the changing law in the area of use of confidential information in negotiations, and I'm thinking of the Lac Mines and International Corona case. I'd now like to look briefly at the situation of an associate joining the firm in which he or she is employed. Obviously, the situation is different from the other two. The associate will have worked there and has a good idea about the firm, its personality, its quirks and foibles. However, and I'm sure I was no different, associates are usually so overwhelmed to get the royal nod and to become a partner that they either ignore making basic inquiries or just ignore what could be potential problems. First of all, the associate should request full financial disclosure. In most firms, associates do not have this, particularly in respect to the capital contribution that the associate will be expected to make. In many firms, this is significant and the associate is not aware of this until he or she is invited to become a partner. And as all of you know, usually associates are invited to become partners at a time of life when they have heavy other financial responsibilities, such as family and mortgages. The associate should be aware of philosophical and personality disputes in the partnership. Often, as we all know, these are based on remarks of disgruntled partners or associates and are just human relationships and do not indicate severe problems. But in some cases, they might indicate severe problems, and the associate should be aware of these. In summary, in all three situations, the new partner should make appropriate due diligence inquiries. And again, in the case of a new partnership, I believe it's essential that the partners at the outset negotiate and settle a form of written partnership agreement, if only to raise issues in differing philosophies and resolve them hopefully at the outset. I've talked generally about the formation of a partnership. I would now like to look at 2 or 3 issues that come up upon the formation of a partnership and the negotiation of an agreement, which in my view, if not settled amicably at the outset, will lead to difficulties down the road. The first one, and perhaps the obvious one, is profit sharing, or the annual distribution of profits. I think every partnership must review whatever system it has on a regular basis and adjust it annually. And also, for it to work, the majority of partners must at least believe that they've been treated fairly, even if they're slightly unhappy over their allocation for that particular year. The basic principle behind partnership distribution is very simple. The income of the partnership shall be allocated among the partners in each year on a basis which reflects the relative contribution of each partner to the firm in that year. Sounds simple, but the key words and the difficulties are relative contribution. It varies tremendously. The system varies tremendously from firm to firm. In most firms, it does take into account some obvious factors such as the capital contribution, so that the partners do have enough cash flow to pay the interest on that. With the help of magazines like American Lawyer and Canadian Lawyer, our profession has developed a number of buzzwords or terms for the various systems. Eat what you kill, meaning a system based solely on gross billings. The bear pit system, where apparently partners lock themselves in a room and don't come out until they've decided. I'm sure in my firm it would lead to 2 or 3 homicide charges at the end of the procedure. Split the pie. This is the more common system, certainly in larger firms, where the whole problem is dumped on a committee and they make the allocation, for better or worse. And in some firms, there is a strict formula basis. American writers in this area have developed formulas. The best known one is based on one used by a Boston law firm, Hale and Dorr, where it's a strict unit system that takes into account everything, not just gross billings, but time spent on marketing, client retention, firm management. It would be very presumptuous of me to recommend any particular system, but I do think there are a couple of basic principles that could be kept in mind. First of all, if a firm has a strict formula, the formula should be adjusted and reviewed regularly to take into account changing circumstances. 20 years ago, marketing activities were unheard of in our profession, at least in a formal sense, and I'm sure later this morning Milton Zwicker will tell us that marketing activities are essential. Someone has to do it and someone has to be rewarded. A strict formula developed many years ago may not take that into account. In my view, the best system is a combination of a formula and discretionary elements. With a formula based on gross billings, the partner is at least guaranteed a basic cash flow. The discretionary element, however, provides the partnership with a way of rewarding these very important activities that can't be necessarily measured in dollars or in some other definitive way. And in my paper, I've given a simple example. A partner who bills 1,800 hours a year but has taken no role in client development, associate training, firm management, may not have contributed as much to the firm as a partner who's billed 1,600 hours a year and yet has contributed heavily to these other areas. I think the system should also have an averaging system to cover fluctuations. A law practice, as we all know, like life, is not a steady line. You have good years and bad years. And at least with an averaging system built in, the partner is protected from sudden fluctuations in income. In closing, there's no perfect system, but it's a very important one that must be considered at the outset. And as long as the system chosen is perceived to be fair by the partners, it will not be a source of aggravation in the partnership. The other important issue that should be considered and resolved at the outset of a new partnership is the question of admission of new partners. First of all, the rules must be clear whether or not the admission of new partners requires a majority vote or a unanimous vote, so that the new partners know, if it's a majority vote, that they may not have a final say on the admission of a partner, or if it's a unanimous vote, that every partner has a veto. I found that in the negotiation of a partnership agreement, often this one issue brings out differing philosophies on growth, in that two very compatible partners and practices are going to merge, except one expected that it would perhaps grow to a 3-man practice in 10 years, and the other partner was hoping to have a 20, 30-man practice in the same period. The question of admission of associates is always a sensitive one. In my view, the partnership agreement should define the quantifiable rules, and that I mean the years of service, the minimum billings, and other definable characteristics which are expected of associates to be admitted to partnership. Now, there are obviously many other characteristics, well-rounded individual, good client attraction, retention skills, community service, but as we all know, the perfect associate, like the perfect human being, doesn't exist, and all of us are strong in some areas and weak in others. If the rules are clear and an associate does not become a partner, he or she knows why, if he or she has not met one of the definable rules. And this is a very important issue in small partnerships. If associates are not admitted to partnership and feel they've been treated unfairly and leave, usually they take clients with them. In larger partnerships, the loss of one or two associates for these reasons may not be detrimental, but it may lead to overall associate poor morale and therefore have a real impact, adverse impact on the future of the partnership. I also recommend, as an aside, that associates should be advised annually of their partnership chances and how they're doing. The last area I'd like to look at briefly that I think should be addressed at the outset is income from outside activities, or really participation in outside activities. There are two factors to be looked at, the time factor and the income factor. Dealing first with the income factor, the partnership should decide at the outset whether or not income generated from these activities is partnership income or not. One common source of income are directors' fees, and if one partner builds up a successful commercial practice and generates significant directors' fees, it's difficult down the road for the partnership to say, well, we want those fees back in the partnership because it's as a result of the partnership that you have these fees. Usually the partner will counter, it's me being on the board that keeps the corporate client in the partnership, so I should keep the money. If this issue is addressed at the outset, it doesn't become a source of contention later. And I focused on directors' fees, but there are many other fees for all types of practices, duty counsel fees, bar admission teaching fees, even fees generated from being on municipal boards, school boards, that are a necessary part of practicing in a smaller community. Part of the same issue is time factor. There are many activities somewhat related to the practice that involve a lot of time, again, serving on boards, perhaps even running for Parliament or running and being a member of the provincial legislature. Often these activities will generate clients and benefits for the firm, the partner who's doing it will want some kind of reasonable remuneration for these activities. A side issue that other speakers will address is the question of firm management activities too. Increasingly, lawyers have to spend more time, or at least some partners have to spend more time managing the practice. Again, a partner's not going to do this unless he or she feels that they're going to be remunerated in some manner, and this should be addressed at the outset. In summary, on the formation of a new partnership, I believe it's essential that the partners have a written partnership agreement to consider and resolve all of these issues. And in the case of all partners, whether forming a new partnership, joining an existing partnership, or becoming partners, just basic due diligence will, in my view, save that partner a lot of grief down the road. And maybe if problems come to light and are pointed out to the other partners, will save the partnership difficulties. Thank you very much. We'll now move on. The partnership's been set up. It's now time to consider management of the partnership. At this point, I take pleasure in welcoming one of the experts from an outside field who's with us this morning, Linda Ferguson, who's a senior consultant with Woods Gordon. Woods Gordon have a section that's devoted pretty well primarily to law firm management consulting. Linda is part of that group. She comes to this field with a wide experience in banking, in hands-on law firm management, and has participated in many management studies and also many activities for consulting associations, the Canadian Bar Association, and similar organizations. Linda is a graduate of the University of British Columbia. She's left that wonderful land to move to Toronto. Thank you. If you'd like to add that onto your hotel,
I'll move. Good morning. My topic this morning is managing a law partnership. Now, I have had some experience in assisting lawyers to manage their practices. On occasion, I would say I've even managed a lawyer or two. I can't say that I have ever really managed a law partnership, and I really don't know of anybody who can. It's one of those difficult organizations to handle. However, all of that doesn't keep me from telling you how to do it. First of all, when you look at management roles in law firms, you have to define what the difference is between leadership and management. What is leadership? Well, according to Webster's Collegiate Dictionary, a leader is a person who has commanding authority or influence and the ability to lead. Management, a manager is one who exercises executive skill, has administrative and supervisory direction, a capacity for managing. There's a difference between those two. Leadership is an internal attribute. That is, we all know people who are leaders, usually people who have visions, and if they're good leaders, they can communicate their visions well and people follow them. Managers are the people that try to turn the vision into reality. Generally, they're people who want more to conform, and leaders want to see change. There is another definition of leadership for leadership and management. A leader is also a horse placed in advance of other horses of a team, and to manage is also schooling or handling of a horse. Now, I didn't really want to speculate on how those terms came about applying to lawyers or to horses. But obviously, I'm confusing lawyers and horses here. I didn't want to speculate on how those terms came about, but several of the management committees I've sat on would lead me to understand why those terms could apply. My favorite definition of management, however, is the judicious use of means to accomplish an end. How does management work? Well, it works most effectively when it's combined with leadership. And that means if the people that are leaders in the organization, whether it's a one or two or a three-man firm or larger, if the people that are the leaders are also involved in the management, then you will have a very effective process. You can make things happen. If, however, it's perceived that the management works in opposition or outside of the leadership group, whether that's perceived as being real and whether it is indeed or not, it doesn't really matter because things won't happen. For example, I worked on a management committee which felt it had authority to do things, and it had some very exciting ideas. There were, for example, some associate evaluation procedures that were going to be put in effect. And the committee went happily away developing the new forms and so on and procedures for doing associate evaluation. However, it wasn't presented to the partnership until a later point, and as it happened, a particular partner who had leadership characteristics blocked the committee from doing that, absolutely, adamantly refused, felt that it was unprofessional to evaluate associates by putting comments on paper. And so there was a perception that the management of the firm was moving in a direction that the leader wasn't happy with. Now, there are a number of different management structures that can be found in law firms. There's the malevolent dictatorship. That's the despot who has very definite ideas about how things will be done, and they will be done that way. This is the person who will tear up a letter if it doesn't conform specifically to the format and margins they've decided on. There's the benevolent dictatorship. That's where there's an illusion of democracy. It's usually a pleasant individual. Others in the firm, whether they're staff or other lawyers, will have the illusion that they're involved in making decisions and creating plans. And what will happen is, sooner or later, that benevolent dictator will step in and make a decision about an area that someone feels they have jurisdiction over. They don't truly have that authority. The dictator is controlling all of the situations. There's also full democracy, where every partner, great or small, is involved in every decision, every major decision. If you have a consensus democracy, as you can imagine, very few decisions are ever made. If you have a clear majority democracy, then sometimes you can't actually accomplish things. Then there's the partial democracy and elected group. That usually occurs in a partnership either where there are very few people who are interested in management, or alternately they're sick and tired of dealing with it, or they've grown to the point where they can't deal with it anymore. So they create a management committee. There is the democratic dictatorship where you have an elected individual, elected or appointed. And again, that's a trend where you're trying to restrict the number of people who have to be involved in that day-to-day management of the firm. It may be a managing partner, or one of the new trends would be to bring in perhaps an outside person, a law firm manager or a CEO type. There's default management, and I've seen this occur in some firms too. That's where nobody really wants to do it. And so someone will be forced into the situation either because they're deemed to be sympathetic and people will bring their problems to them, or because ultimately they can't stand a certain situation occurring and they'll deal with it. Traditionally, what happens is that person will get fed up also having to do a marginal amount of management work, and it will revert to a full democracy. Now, I've shown a little chain of boxes here. And as I've indicated, default management usually reverts to a full democracy. As well, over on the left, there's the malevolent dictatorship. Usually what happens when a malevolent dictatorship, the despot, turns over is either there is a new equally despotic environment, or in reaction, there's a palace revolt, and it reverts to the full democracy. Sometimes that's a move to block the despot from being able to do anything, where you revert back to a consensus democracy. In a full democracy situation, usually the chain is to opt for reducing the management group because the partnership is continually faced with making all of these petty decisions. And so they restrict the number of people involved. That's where you elect your management committee. From there, the deciding group gets smaller, moves into your democratic dictatorship. Now, as that person's comfort level grows in terms of decision making and the amount of authority they have, it moves into a benevolent dictatorship, and usually that's a comfortable situation for a while. You have a managing partner who effectively just makes all of the decisions, runs the firm, does the long-range planning, and so on. But eventually a change will take place. There might be new partners coming on board. There might be young associates who are becoming more verbal about their concerns about the firm. And typically that benevolent dictatorship will be overthrown again, and you'll revert back to the democracy. So there's kind of a never-ending chain that goes on in most law firms. The management style isn't static. I'd also like to define the difference between management and administration. These are partly for my benefit, the way that I think of what management role is versus administrative. Management is broad in scope. It deals with large issues. It also deals with the external environment. What's going on out there? What is the competition doing? That sort of thing. It involves planning, looking at the various issues in the firm and what needs to be dealt with. It incorporates the firm's goals and critical success factors. So a management issue might be dealing with, for example, the number of new associates that should be brought into partnership. Now, it will make decisions in light of what the firm's goals are. If the firm's goal is to retain a size of 5 or 10 lawyers, then naturally there won't be a decision to hire 8 new associates. Management also has a clear understanding of the firm's culture, and those are all the little quirks and personalities that make up a particular firm. Administration, on the other hand, is narrow in focus. It's largely an internal event. It deals with the implementation of the plans and the details. It incorporates the measurements of the success factors. So, for example, if the firm goal was to reduce their exposure, that is the level of accounts receivable and work in progress, then the administrative side of that might be to implement the system for dealing with it, either generating form letters to go to clients, automating your billing process, that sort of thing. And administration is directed by the firm's culture. And this, you can think of even very small examples for like message handling. In some firms, all calls go through directly to the lawyer. In other firms, they have to be announced. The administrative side is dealing with whatever the culture is to keep the lawyers and others happy. The two most significant management activities are planning and making sure those plans are implemented. Planning makes sure that all activities in the law firm are consistent with the firm's goals. And I've seen so many examples of occurrences where decisions are made without planning. For example, a telephone system will be acquired, and that particular system becomes obsolete in 2 or 3 years because although the firm had made a decision previously that it was going to grow to a larger size, that wasn't taken into account when the purchase of the telephone system was made, and it wasn't purchased to fit in with other automation plans. Planning takes lots and lots of time, but it saves money. Planning is top-down in direction. That is, you can't ask your secretary to create your long-range plans. It's an owner-driven activity. It's time-consuming. It's not something that necessarily lawyers like to spend their time doing, but it's critically important for you as partners to spend time doing it. You have to take a look at what the current conditions are, the competitive environment, what particular areas of practice you're handling in your firm, whether you might want to examine making changes there, what your existing equipment is and how you're using it, what your staff structure is like. You have to then anticipate the future condition, either the one that you wish to create, that is, that you want to open new areas of practice within your firm, or what you think the world outside is going to be like. Or the fact that leasehold space in downtown Toronto is getting tighter and tighter and more expensive. What impact will that have on your plans? In light of your areas of practice, does that mean that you need to stay downtown, or could you move to a less expensive area? You also determine the possible courses of action. That is, you should take a look at a number of alternatives to achieve your end result. And those alternatives might take the form of different costs. There's a high-cost method, a low-cost method, or it might be actually different procedures to arrive at that end. And then in planning, you choose the course of action that's most likely to succeed, maximize. The important thing about planning, too, is that you have to continue to monitor your plan and change it as conditions change. On the implementation side, of course, your plan can be wonderful, but if you don't put it into effect, how much good has it done you? And the implementation is turning that into a reality. For example, on an administrative activity, for the implementation side, once a decision is made to bring in a new computer system and generally what functions will be performed, the administrative side might be going out and collecting the data on various kinds of equipment and making a decision about what specific piece of hardware you bring in and arrange for the purchase and lease. The implementation is also comprised of all of the minute detail that goes into it. Again, with your computer system, you don't just bring the box in and sit it down and things happen. There are a lot of details that have to be looked after. For example, do you need to create new forms to deal with this, the way the process works? How are the forms collected? Who handles it? How are any reports distributed as well? So I'm indicating that while it's a time-consuming process, in order to achieve an end, if you do your upfront planning, that will only consume 20% of what the total project entails. The balance can be handled at the next lower levels in terms of actually implementing it and the ongoing maintenance. Of course, the maintenance is the longer term. So planning doesn't need to be done initially in great depth and detail. You don't have to do it all at once. You don't have to go out and research and create a huge volume. It may just be scraps of note paper thrown together in a folder. The important thing is that you sit down and determine what the firm's goals are in all of the critical areas and start creating your plans one at a time that will conform to those particular goals. Now, what areas would you look at for planning and implementation? The key areas in law firms are, of course, the financial aspects. And, of course, Bill Strain is going to talk to you about tax attributes later. There are other financial matters as well. Technology and automation, practice matters, personnel, operations, and business development. Now, I'll expand on these a bit. For example, some of the tasks you might set yourself in the area of finance are creating revenue and expense budgets, say from 1 to 5 years. That's usually an effective range. You tend to be more accurate, of course, for the short term. It's surprising how many firms are not creating budgets. In fact, lately I have walked into a firm that's a medium-sized firm. It has over 20 lawyers that does no budgeting whatsoever. It doesn't know how much revenue it will make, and it doesn't know what its expenses are. I have been in a couple of firms, several actually, that will create an expense budget because they want to control their bottom line in terms of what their costs will be, but they refuse to set a revenue target. All of the lawyers are afraid they'll be held to it. Now, it seems to me that it's very difficult to determine how much you're going to take home at the end of the year if you don't know how much you're going to gross. And so it's important that you take the time, even though there is a resistance to naming a name, naming a figure as to what you're expected to bill, you have a reasonable expectation. Firm capitalization methods. You might want to take a look if you feel you're undercapitalized, you're looking at major expenditures over the next few years, or just because you're creating a new partnership and you want to take a look at an effective means of making sure you've got a good footing. You want to consider some of the things that Bob talked about, like how much it might cost for a new partner to buy in. You also might want to look at each partner leaving some portion of their profit share in their capital accounts each year to build up a pool. Another alternative, of course, is to go to your bank and get a loan, perhaps to finance your receivables. Partner compensation methods, and again, as Bob indicated, this is a difficult area to deal with. It's very important to set up some effective methods. One of the trends these days, of course, is that there's more recognition for time and effectiveness of management and marketing activities. That is, it's not enough just to devote some time to doing those things, but how well did you do it and what were the results? Billable hours targets. And again, sometimes this is difficult for lawyers to deal with, to set down a target for themselves as to what they will record in terms of billable hours. But there really is a relationship between billings and the hours recorded. Accurate time recording is probably one of your single best management tools for increasing your bottom line as well. Even if you decide not to bill all of the time on your file, at least you're making an informed decision. Receivables collection standards. I've yet to walk into a firm that was satisfied with their level of receivables. I have been into one, and that is because their system of compensation was totally based on collections, and it was much like traveling through shark-infested waters. They were so tough that in the event you didn't collect a receivable, a year later it got charged back to your profit share. So naturally they were very, very good at collecting their accounts. Aside from that one and only firm, I have not seen a firm that was really satisfied with the level of collections. Lawyers work very, very hard and put in long hours and provide quality services to their clients, but somehow don't feel comfortable asking people to pay them for doing that hard work. So one of the areas you should look at is perhaps reducing your exposure. Now, your exposure index is made up of a combination of work in progress and receivables. It's basically how long it takes from the time you physically do the work till you actually collect the money. An average is 5 to 6 months in most firms. So it's one of the targets you might set for yourself is to reduce that by a month, which is going to put money in your pocket. Another area that you might look at is non-billable hours, the investment versus the return. And firms now are starting to look at requiring certain non-billable activities of their new associates and partners. And that non-billable activity might be marketing, it might be involved in firm management, it might be CLE activities to make sure that all of the lawyers keep their skills up. But it's determining how effectively that time is spent. So, for example, in a marketing activity, although there might be more profile gained from being involved in a United Way campaign, perhaps the better place to get the contacts would be on a particular ball team that you might coach or play on and the people that are involved. Some areas in technology and automation, some of the automated techniques that are being implemented in firms include online legal research. I'm sure all of you are familiar with Quick Law, and you can probably access it through your library. There are other kinds of services, though, too, and if you're a corporate lawyer, you may be looking at researching, for example, some of the articles. Wall Street Journal and several other publications have online research services where you can go back and research articles that they have produced over the past several years. In addition, there are some government services that are available. And those might cover economic indicators, information about exports, commodity pricing, and so on. Automated litigation support, and again, this has been a fairly popular topic. All of the barristers have probably heard of it, if not been exposed to it. There are outside services. You can also do it in-house. It's a procedure for keywording and indexing your documents and transcripts and exhibits so that you can instantly retrieve them. Now, there are different methods of implementing it. It can be just keywords and sort of head notes concerning the particular document, or you may have actual full text stored on a computer that can be retrieved. And when you get into very complex litigation, it's valuable to be able to lay your hands very quickly on a particular document or where a piece of information is stored. There are desktop tools, and more lawyers now, particularly younger lawyers coming out of law school these days who have had more exposure to computers, are using some of these desktop tools. Some of them are kind of fun, too. For example, there's calendaring, where you may store your calendar, but it may be tied into a network for the other lawyers to store their calendars as well. And this can apply to a very small firm where there might be just 2 or 3 computers spread around. What it helps you do is to keep track of what the other person is doing when you want to arrange a meeting. I don't know how many of you have ever tried to arrange a meeting of more than 3 lawyers. It's very difficult. And there were lots of times I would have liked to have had this facility available. You can put to-do lists also on your system to remind you of important things that need to be done. Tickler systems so that the particular date when you log on will trigger a mechanism to advise you that it's your wife's birthday and you better buy a gift, or that there's a particular client you should be contacting, or a limitation date is coming up, and so on. You can also have your phone book tied to your system, and you could have your computer system, this phone book, tied in as well to your telephone, so you could bring up the individual's name on the screen. It would automatically bring up their telephone number and dial it for you. Some of the kinds of tools that some lawyers use as well is to update information about their clients. As they're talking, they can use it for time recording. That is, at the time they finish the call, they've logged it against the file automatically. They also use it to record little things like, spoke to so-and-so, his wife was in the hospital. So the next time they talk to that important client and they bring that person's name up on the screen, the first thing they ask is, how's your wife? Is she out of the hospital now? There are also expert systems, which is basically software which incorporates the legal issues, the precedents, and the logic into a piece of software through various levels. And what that allows you to do is to let law clerks or legal assistants handle some specific practice areas. It takes people through a decision-making path. Even if it's an area of practice you're not familiar with, it will take you through a yes or no or fill the blanks path, and will ultimately produce the documents. Some areas that really lend themselves to it are real estate practice and wills, for example. And the documents will be produced. Any follow-up dates will automatically be diarized and put into the Tickler system. There are marketing database and management systems now. This is really hot stuff in the larger firms, particularly, where they're actually creating new positions for people to handle marketing. And I don't want to spend too much time on that because I know that Milton is going to be covering off marketing issues later. But it's just a method for developing your client contact lists and information and doing effective follow-up and mailing lists and so on. Management reports are another area that you should be looking at if you have an automated system. For example, you might want to be able to produce your aged work in progress or receivables lists, area of practice reports, so you can see if you're actually profitable in a particular area of practice. One that quickly springs to mind, for example, a general practice I worked with, they had never looked at their nature of practice reports, and when they finally did, they discovered that they were losing money like gangbusters in the criminal practice. And it was something that, they were vaguely aware it was marginal at best, but they didn't realize how much money they were losing on it. and actually made a conscious decision then to cut back on the criminal practice. Another one is, for example, word processing usage, or abusage, actually, as most operators would consider it. And that is, you might want to track things like how many drafts a document goes through. In some firms, there are averages, like for long documents, of between 45 and 60 drafts. You have to think about how effectively the lawyer is using his time if he's redrafting a document that many times for a single purpose. Oh, heck, I'm getting carried away here. Billings generation, automated billings generation, too, is something that a lot of firms strive to do because it speeds up the process. And basically, it involves improving the accuracy of your initial data entry so that your secretaries perhaps are keying in timesheets and time information. And provided the system gives you a flexibility in terms of the kind of verbiage you might use or the standard text, and the ability to edit your bills or to create them in the format that you particularly feel comfortable, you can set up a process to generate the bills without having your secretary retype all of that information, or to automatically produce a list of bills based on various criteria, such as anything that's over 6 months old and over $500. Desktop publishing, and this can be used for a number of purposes, partly in a corporate area. Some firms now are producing, effectively setting up the new client prospectus in-house on their own system, communicating it to the printer's office direct to their typesetting machine so that it doesn't require further proofreading at that point. Another is to create very professional-looking newsletters and brochures. Okay, there are practice matters as well, such as in-house training, where you may want to pass on the expertise that some of your lawyers currently have through a series of seminars, or where in order to cut the cost of sending people out to seminars, you may send one person who then has to come back and pass on to his or her colleagues all of the information that they acquired. There are new practice areas, and this is something you have to be, particularly aware of if you're looking for expanding your practice. For example, years ago, computer law was not in existence. I did hear as well an example of a lawyer who saw a unique opportunity and seized it. He's a lawyer who's very active in a gay community and also very active in fundraising activities for AIDS research. And out of those activities, he's developed a new estate practice. Morbid, but true. There are conflict of interest systems. This is particularly important if you're going to merge your practice with that of either another lawyer or a group of lawyers, or two larger firms merging together, to be able to check quickly and accurately to see if you have any conflicts. Now, some of the newer systems do some exciting things. They won't just check for an exact match. They'll also check for things like sounds like or looks like, so that if you've got a misspelling, that it may pick that up as well. Handling of legal opinions. This is an important practice matter, particularly where you get into some larger firms. Even a firm of 10 lawyers I'm aware of that issued 2 conflicting legal opinions, basically to deal with, they both went to the same client, unfortunately. They were dealing with different matters, but you should be looking at setting up systems to make sure those things don't happen. Quality control. And those are issues where you want to develop and monitor the lawyer's skills in the firm and in turn what staff are doing. You want to minimize your potential liability situations. And one of the most effective ways to do this as well is to deal with case acceptance procedures, how you take on a matter and when you should, and whether or not it should also be discussed with another partner or lawyer in the firm before you do take it on. Team project management, where you get a complex matter and you're involving a number of people in the firm, you should be setting up some system for dealing with it. One person who has the ultimate authority, then some method of producing checklists that have dates, times, the people who are responsible for the activity, and some method of ensuring and following up to make sure that they do it. In one firm, there's a system where a file may not be handed to another lawyer, refiled, or go anywhere until the next date is placed on it for an activity and what that activity is going to be, so that there's always some measure of following up and making sure it's going on. Ultimately, the person who's responsible for the file should have some method for keeping track of what's going on it. Personnel strategies. One area that is frequently abused is effective recruiting. For example, articling students. That's your best chance to pick your potential future partners. You should be looking for the skills and personal qualities in those individuals that you would someday hope to have as partners. And the beauty of it is you get to train them your way. They haven't come from somewhere else with all of those terrible bad habits, and so that you spend the rest of your years trying to break them up unsuccessfully. Also, recruiting good staff and keeping them. The evaluation process. Now, I was to talk a bit about finding and keeping good people. Probably the evaluation process is one of the single best tools you can use. The 3 top complaints by associates, by students, and by staff members are not money. Money doesn't figure into it. They are lack of feedback, lack of input into decision making, and lack of defined responsibility or authority and what the lines of authority are. Those are the 3 toughest issues they deal with. They ordinarily, they don't know what the firm's standards are for their work. They don't know how they're being judged in relation to the standards. They feel that decisions are being made which dramatically affect them, to which they are not being invited to even express some ideas. They're not asking for the power to make the decisions, just to input into the process. And also to find out what they are specifically allowed to do and not allowed to do, and who they go to take the next step. If you want to keep good associates, that's the way to do it. One of the best ways to handle evaluation as well is to do it semi-annually. And I know there's a big resistance to sitting down and actually talking to someone about their performance. But if you do it semi-annually, you can do it once when it's not tied to money. So the first time you do it, you can talk to someone about where their work may need improvement or where they're doing exceptionally well. What it does is create a more honest evaluation, because you know you're not going to be penalizing somebody. The fact that you're unhappy with the way they handled a certain matter doesn't prohibit them from getting a good increase. So you'll get an honest evaluation, and also you're giving the individual time to make a change in behavior if it's unacceptable, so that the next evaluation will then form the basis for a salary change. Staffing structures also are something that many firms are looking at. Your single biggest expense item is staff salaries. And so any way that you can effectively use people, usually by incorporating more automation into your practice, is something that you'll be looking at. More firms are trying to use shared secretarial situations, perhaps work groups to maximize the use of particular staff and lawyers, and also looking at leverage so that they're bringing in people at a lower cost to produce the service, using law clerks and associates to handle more of the client work at a lower rate. And that works fine provided you've got sufficient work to keep everybody busy. Compensation and benefits. One of the new methods that firms are dealing with the benefit situation is flexible benefits, because there are a lot of 2-income families now. Instead of just handing a package of insurance plans to someone where the spouse already has that particular range, they'll offer the money instead, or the insurance, or a combination of the two. Associate compensation, too, you have to look that there are changed expectations in terms of what you look for in associates now over what took place perhaps 10 or 15 years ago. Therefore, you should be changing the method in which you compensate them as well. And much in the same way that partnership compensation takes place, as Bob outlined earlier. You may want to consider bonusing or some measure of, some method of allowing them an interest in profit sharing or a bonus based on profitability. You may be looking at lateral associate hires, particularly where you lack in a particular experience level. Some firms end up with a gap where they've got a very senior person or a group of people and very junior and no one in the middle. And as retirement ages start to approach, it leaves this huge gap in terms of client service. Now, in the outline, it also indicated that I was going to deal with associate partnership aspirations. Well, most associates do have partnership aspirations, and I guess I could just want to reaffirm what Bob said earlier, and that is that you should let them know at the outset what the criteria are for partnership. You should have defined the criteria, but you might also look at some of the new things that are happening in the world, and that is there is a new class of associate called career associate being developed. Some people may not want to ever get into the partnership. They may not want to have to deal with all of the kinds of planning issues and management. They may not be particularly interested in having their income based on the profitability of the firm. They might be quite happy just to deal with a particular salary or something that's based directly on their billings. Operations, there are in-house services such as a full-time messenger, space planning. These are all more the administrative activities, the space planning, leasehold arrangements that you might create, developing your insurance policies, making sure you have contents, liability insurance, whatever life insurance you need under your partnership agreement. Records management, which is part of the game of file, who's got the file, and developing a system for being able to track them. Workflow handling, what happens when somebody's sick, who handles the work, how is it delegated, what type of work goes to word processing, and so on. And your physical plant and equipment, and that's basically just the maintenance and repair of your equipment and your leasehold space. Business development, which I'm only going to touch on briefly because Milton Zwicker is just about to talk to you in depth about this area. But there's the ever-popular firm brochure. My favorite was a particularly tough firm noted for high turnover that used a loose-leaf approach so that you could easily remove lawyers or add them at will. Public service activities, such as boards of trade or a charitable organization. Event sponsorship, perhaps an art-related like a ballet or a football game where you're getting credit in a brochure or a program. Newsletters, where you may send it out on a single topic to a particular type of client or where it may have a multiple approach, a number of kinds of articles. Your contact lists, very important. Who's who do you know that you can generate work from, or who will be a sphere of influence for you, who will direct more work to the firm. And most important, how to retain your existing clients. As you're probably aware, the single biggest complaint that clients have these days is the fact that they feel that they're being passed off to juniors and they want contact with the person that they know in the firm. So that's something very important to keep in mind. So, briefly in summary, the management structure of the firm can take many forms. However, to be effective, it involves leadership and support of, and I should say by as well, of the partnership. Significant activities are planning and implementation concerning all areas of the firm's business, such as finance, technology and automation, practice matters, personnel, operations, and business development. And again, I encourage you to start your planning. Don't consider it a bound volume that collects dust in a corner somewhere, feeling proud of yourself that you've developed this wonderful plan. It's something that's living, breathing, changing every day. The success of the management is going to be measured by the results. And that means the type of management approach you use. For example, if you have a consensus democracy, you have no results, and that tells you something. The success of your planning, did it work? And the success of your implementation, how well did it work? And I wish you good fortune in managing your firms. Thank you. Okay. Oh. Thank you.
We've now hopefully properly formed the partnership, and thanks to Linda, learned how to manage it. The next, one of the important activities of a partnership, getting and keeping clients. Our next speaker needs little introduction. I don't know whether it's an example of excellent marketing or poor marketing, but there's no biography included in the material. But Milton is well known to many of us. Milton practices in Aurelia, and I assume that Evans and Lewis and other hard-working partners and associates are there to look after all the clients while you're out doing marketing seminars and marketing. Seriously, it's a credit to Milton that he is a well-known expert in the area of law firm marketing, and he is often referred to in the large number of American articles or articles in American legal periodicals on marketing, and so he is a well-known expert and one of the earliest experts in the field. Milton? Milton was going to arrive on an elephant, but we told him he'd have to tone down.
Good morning. Morning. Who's heard me before on marketing? Who's never heard me? Who's not sure and don't care? I like doing little demographic surveys as I do these seminars. Kind of like to get a feel for the audience. Any solo practitioners here considering going into partnership? Yes, there are. 2 to 6 lawyer firms. 6 to 12. Over 12. So most of us are in, I guess, firms like mine, small law firms, 6, 7, 8 lawyers, dozen maybe. As I sat and listened to our last management consultant speak, it sort of reminded me of the story of a friend of mine who was a management consultant and was asked to do a survey for a bar association of the attitudes of the legal profession about management. And so this management consultant had a few friends who was lawyers, so he thought he would start with them. So he phoned up his lawyer friend and said, I've got this study to do. What do you think's the worst problem that lawyers face with management? Is it ignorance or apathy? His friend said, I don't know and I don't care. At least I know enough about marketing that I'm not going to try and develop an estate practice in Aurelia with the gay community. I don't think it would succeed. I kind of like room here to move around. I learned a long time ago, and my friend who introduced me called me an expert. Well, I learned a long time ago, and this is a morning smile from the Globe and Mail, that an expert, someone who knows no more than you do, but has it better organized and shows slides. So I always show slides. You heard it, that there are changing economic times in the legal profession. What you did yesterday, you can't succeed with today. And increased, intense competition, increased overheads, increased turmoil, rapid changes in the law. Those are the things that are impacting you and I on a daily basis. We look at that and say, what are the solutions? Here's where I'm coming from when I talk about marketing. I'm going to make this statement, and then the rest of the seminar, or this talk about this, is going to be to support this. And the statement is this: revenue enhancement is more productive than cost containment. And law firms have been set up for a long, long time, and I often talk about this, and sometimes I bring this three-legged stool with me. We have to produce like a manufacturing department or any other company, whatever it is, whether it's a service or a product, we have to produce it. We also have to finance that particular product or service. And we have to do something else to make it successful. We have to market it. In fact, somebody once asked Henry Ford, when he was describing those three attributes of every business, which one is the most important? And Henry said it's like a three-legged stool. And I guess it's, for so long, the legal profession, I guess, have been surviving without the one leg on the stool, and our objective now is to try and build that leg. In the short time that I have available, what I want to try and do is set a broad perspective for marketing legal services, give you some idea of the theoretical nature of that, and then give you some ways to do that. And marketing isn't one of these things that where you can say, like a budget in a law firm, you should have a budget. In fact, I'm going to make you a promise, my friends. I'm not going to should on you, but at the same time, don't you should on me. You can't say you should do anything. The key to this is some sort of a plan and marketing to your clients, and the word is needs that I'm going to talk about. And it's difficult to get law firms into this particular area because, as we've already heard many times in small law firms, we all want to be in charge, and yet nobody wants to be in charge. It's sort of, we get more management than we pay for. It's like the federal government. Thank God we don't get the government we pay for. I'm going to do another little survey here. Who thinks here that the purpose of a business, law firms included, the purpose is to make a profit? Hands. I'm coming up for air here. There is someone that I have tried to follow the thought in terms of principles of marketing law firms, and I've been thinking about this for a long time. And I call this particular person the Gretzky of the marketing world. And in fact, if you're going to get into this in a serious way, you must have some overriding principles. It's no good to talk about newsletters because it must fit in some plan. It's not unlike the lawyers who do criminal law to use this analogy. When you go into the courtroom, you must have some theory for the defense to feed your evidence to. Criminal lawyers know how to do that. The driving force, Professor Levitt is a world-renowned marketing professor at the Harvard Business School. The purpose of a business is to get and keep customers, says Professor Levitt, because long-term strategic advantage comes to those who can retain their clients. And so let me just give you the flavor of what Levitt is saying. This is the basis. You must have some basis on which to build a marketing plan. In fact, if you are interested, there is what I'm talking about. Marketing Imagination is must reading for anyone serious about marketing legal services by Professor Levitt. Here's what Levitt says. The purpose of a business is to get and keep customers. While solvent customers, in some reasonable portion, without solvent customers in some reasonable portion, there is no business. Customers are constantly presented with lots of options to help them solve problems. Just a little flavor of what Levitt is talking about. Who thinks that marketing is advertising? Anybody want to take a vote on that one? It's more than that. It's more than that. Of course it is. In fact, I have teased the Law Society for years about advertising. In fact, before you could advertise, the Law Society did not have a file on me. They had a filing cabinet. And if you want to do advertising, then of course advertising is getting attention. And it's one of those elements of marketing that you can do. And in teasing the Law Society, here's my way of advertising. I'm a jogger, so I have my telephone number and my name on my underwear. When you run around the streets in Aurelia, that's my advertising program. Of course I'm joking. I'm joking. They'll be up there tomorrow. But I'm not sure if they put the cabinet away on me. I just got to get some water here. What I'm going to talk about here now is that what my look at what a law firm is today. And the law firm is an inside information generator. That's the circle in the middle. And in order to do it successfully, we have to manage our people, the financial operations. We have to house and equip them. We have to develop people. We have to do legal work with technology. We've already heard some of that in how you manage a practice. That's my way of depicting it. But you must end up, and of course how you do that, up in that corner planning, and we're bombarded with the information from the outside world. But you have to ask yourselves, as you go about doing this, what's it all for? It's for clients. And that's where you begin to think about giving your law firm a marketing touch. And so you begin asking, what do clients pay you for? What do clients pay you for? Clients, whether it's law firms, accounting firms, they pay you to satisfy their needs. Then the next question you end up asking yourself is, what are clients' needs? How do you get at that? because marketing to me is what I call the umbrella approach to doing this. You have to price the service right. It's got to be competent. It's got to be reliable. It's got to be timely. You may want to get some publicity in doing it. You may want to have a public relations program. Depending on the type of practice you have, it may be a totally referral-based practice. It may be a lot of other things, but that's what marketing is. It's all of that, and I guess the way that I have to depict that, see, it's like an umbrella. See, it hangs over the law firm. You have to price it right. It's got to be reliable. All of those things. Isn't this silly? But what fun marketing is. In fact, one of the textbooks in this area, and I'm going to refer, because I'm doing a very quick presentation here, but one of the best books I would at least suggest, if you want to take this far beyond what I'm doing, is a textbook, How to Market Legal Services, by a guy by the name of Denny. I'm not going to take the time to do this, and the reason to give you the publisher and so on. I brought them along. If you're interested at coffee break, you can come and take the publisher. I must say, and I do a lot of review of management books of one kind or another in writings. And in 15 years of writing on management books, I've only ever read one book that's made me mad. One. And it's got to be, in my opinion, can you get sued upon this? I wonder if you say this in public. I'm going to do it. Because it's the worst one I've ever read. It's going to set back the marketing efforts of Canadian lawyers by 20 years if we followed the advice of it. And it's How to Market and Advertise Your Law Practice. It's published by Canada Law Book, written by a guy by the name of Tom Lee. I don't know him. But when you talk, and I mentioned this earlier, revenue enhancement, we know the business equation is simple, that it's profits equals revenue minus costs. But you know, long-term profits equals revenue from happy clients minus the C, which is costs. That's just a little different flavor that you give to it when you start getting into thinking about clients' needs and the things you do for clients. And so how do you get at your clients' needs? Well, first of all, there's a number of supporting studies to help us in this area. In fact, Barbara Kern, for the American Bar Association a few years ago, did an extensive study on the legal needs of the public, there. And what she has said, and it's been substantiated a number of times out of this extensive study, that clients, number one, she found, clients want you to keep them informed. That's a need they have. Two, they want lawyers who show interest and concern in their problems. Now, when you hear things like a consultant telling you that clients don't like to be shuffled off to an associate, what are they saying? They are saying, my lawyer shows no interest and concern in my case. That's number two, if you read the study. I'm summarizing it. Number three was promptness. And guess what? There are 6 items on this list, and nowhere yet. I'm heading into number 4, and I haven't heard the word fee. It's number 4 on the list. They only want a fair fee. Not a cheap thing, not something else, a fair fee. And there's a great discussion in that study about what that means. And failure to explain is the second thing that is a need of clients. And in fact, Bob, I read your paper last night, the one that you're going to end up with, and he talks about the changing atmosphere, even in a large city practice like Toronto, where you think of sophisticated business people that they deal with. He tells us about the need to explain things in either simple language or language where we're not using stare decisis or whatever we talk about. And the sixth one is our working habits. They are concerned. They don't like to come into an office that you can't see the Chesterfield, the window ledges, or the ceiling for files. They are concerned with your working habits. In fact, since I have started working with computers myself on my own desk, I've taken my own room, because you're doing a computer job and you sort of can't shuffle it all away. You ought to either have a small conference room that you go away and your office is cluttered, or I, for example, took and divided my room and put sliding doors. So I have one table and the clients think I'm the cleanest guy in the world. They don't know what's back there. My lunch and all those things are there. But I know about the current study. And I often wondered if that could be substantiated. And the reason I'm spending so much time on this is because if you're going to seriously market, you must know your client's needs. I'm giving you the base for that. It's substantiated. In fact, a few years ago, and there's other things. For example, the fee. This is substantiated, Barbara's study, in what's called the Mobar Prentice Hall Survey. And they were looking at what clients want in regard to fees. And 80% of people who they interviewed and surveyed said they want the lawyer to discuss fees up front. And they don't want don't wait for the client to bring up the discussion. They want it brought up. If you read this survey, the most surprising thing about it, and clients walk away from lawyers and they say, what was the most surprising thing that happened to you while you were in the lawyer's office? He never asked me for any money. They're always surprised. I don't like to surprise them. And you shouldn't either. It's a need they have. It's the same need that you have if you go shopping, whether it's for a loaf of bread or a house. You've got to be in a price range, a budget, something that you can handle. We want to know the price. We want to know it up front. We want to know where we are. They're not saying it has to be the cheapest in town, but it has to be fair and explained. You know, this was substantiated, this study, in another way. And if any of you happen to be interested in this information that you're seeing here, write it down on a business card, give it to me, and I'll send it to you. You just lay back and relax. Don't make any notes about this. Inc. magazine several years ago did a substantial study which they published in a 1984 edition. They went out and asked their business people who subscribed, said, what is it you expect from your lawyer? They went and asked the lawyers, what do you think the clients expect? That the lawyers said, number one, the client wants an expert. The client said, no, we want timely service. The lawyer said, next, we want overall competence. The business client said, no, we want a reasonable, clear fee structure. It's like two railroads going down different tracks, and the idea of marketing is to match those two railroads, to match those needs. So you end up asking yourselves that, how do you do that? And that's some of the things I'm going to. We have to get away from the mentality that we think clients want the greatest expert. I'm not putting down experts. They do. I mean, we have to have them. That isn't the purpose of the study. But we really do think that they come to us for that particular expertise. If you remember, And you can get away from this mentality if you remember this simple thing. The size of your funeral will depend on one thing, the weather. Not that you're the greatest expert in the world. So you asked yourselves, as Time magazine did, what are the things that annoy you when you deal with banks, when you deal with, in Toronto, stock, they have things here called stockbrokers, I think. I'm a country boy, so just kind of don't know these things. The February issue of Time magazine 1987 ended up asking the question, where has service in America gone? You know, you can learn a lot about marketing law firms by reading Time magazine, that edition of it. And a recent article in Fortune magazine, for example, and it's December 7th, 1987, companies that serve you best. The article's written around, what are people asking? Now, obviously, they are asking about, last summer, the Gallup organization, and I'm quoting, polled senior executives at 615 companies on the importance of the 8 factors over the next 3 years, number of 8 factors. 48% of that Gallup poll said the winner by a mile, service quality picked up 48%, way ahead of productivity and way ahead of government regulation. And the services that are offered to our clients, better service, will be nearly as important as making high-quality products. And that's the perception of the world. We live in that world. So we have to, and it continues on, that type of thing. So marketing we have to pay attention to. In fact, as somebody said, the great sociologist Abraham Maslow, you are what you pay attention to. You are what you pay attention to. And I go into law firms, and the law firms start telling me about the marketing plans that they have. Guess how I know my test of where it is? I asked because, Bill, I was trained one time as a bookkeeper, so I know a debit from a credit, and I know you're supposed to have a chart of accounts. So I always look at the chart of accounts, and I look and see if there's anything there for marketing. Is there a budget item for it? Pretty hard to do some of this stuff if you don't allocate resources to do it. So if you're going to get serious about it, you better start doing that. In fact, some of the recent studies where this is beginning to happen more and more in law firms are showing that the budgets for this particular item, marketing, and if you looked at my chart of accounts, you'd see something called marketing, and under it a breakdown of expenses, advertising, brochures, business cards, public relations, client mailings. It depends on how you want to track the costs. But seriously, if you're going to do anything about it, you clearly have to do some budgeting for it. How much time have I got? One of the things that struck me as I have been trying to understand how you market a service, and I'm getting my thoughts from Dr. Levitt. And Dr. Levitt became famous, and anybody reads in this field, in 1960 when he wrote what is now known as his famous article in the Harvard Business Review called Marketing Myopia. And he simply, what the message was that all businesses must stop now and then and ask, what business are we in? And he always gives the famous story of the railroad, of that the railroads thought they were in the railroad business instead of the transportation industry, and as a result, they didn't go into the airlines industries, most of them. and they disappeared. I always think there's one in Ontario that's my favorite one, the company who made the metal garbage pails. They thought they were in the metal garbage pail business instead of the garbage disposal business, and no way were they going to switch to green garbage bags. Well, what happened to them? They disappear. So you have to sort of get away from that type of myopia and ask, what business are you in? And you know that clients want information. You can sell, for example, now clients packets of information on certain fields of law. I've tried this. They don't necessarily have to come to the office. So I look at it as saying that, well, perhaps, and this is a favorite that everybody's using this, and I'm not sure where it leads, but if you look at it as being in the information industry, clients want a lot of information. They want copies, for example, of the correspondence they want copies of that. They want to know what's happening. They want you to explain the law in terms that they can understand. So they're looking for information. So you must know an awful lot about your clients, your industries. For example, surveys have shown, and lawyers look at the yellow pages, it's full of it. Lawyers advertise and say, our firm does litigation. Clients don't know what that is. They don't know what litigation is. They don't know what a tort is, as I didn't until I went to law school, and I likely still don't. So the formula for success is as old as the hills. Find a need and fill it. And in order to find out your client's needs, where do you start? You ask them. You ask them. In fact, trying to market legal services without client feedback is like trying to target shoot with a blindfold. You can't do it unless you're Annie Oakley. You've got to ask them. And you can do that in a number of ways. You can simply take over the next 2 months, make a list of the 10 people that you consider are important to your practice in your law firm, and say, over the next 2 months, if you want to start a marketing strategy, and some of these you do and some are successful. I can tell you I've been doing this long enough that I've had likely more failures than I've had successes. Like, for example, I tried the thing of advertising in a hotel. You know, in the bulletin board, you go in, you phone your doctor, your lawyer, your dentist. I'm there. Complete waste of time. I wasted my money. But those are the type of things in marketing efforts, trying to serve clients, thinking about needs, and as Tom Peters said, in Search of Excellence, what do the best companies do? They try things. They keep trying things. They have more failures in products or whatever it is than they have successes. But if you're not trying, another way, of course, to get at clients' needs is and I and others do this, every time we finish with a file and send the client account, in my firm it goes out on a simple piece of letterhead where you ask the client, in order we might provide you with better legal service, it goes on. What did you think of our service? Was the fee right? Did we keep you informed? Did we return your telephone calls? You get client feedback. Sure, you get some who think you're great, and you get complaints. You likely don't pick up in that thing Mr. Average in between, but complaints are important because we know from marketing studies, and I have one here that was done for the Ford Motor Company that indicates that if you get a lemon, you tell 22 people about it. If you like it, you tell 8. So if you do a flop in your law firm on a marketing technique, all you're trying to do is stop them bad-mouthing. So to give you an example of what we did, okay, had a real estate transaction, asked for a purchaser in a small city, of course, small town. We do, like most of you, I'm sure, do a lot of residential real estate. Something goes wrong. We don't think it's wrong, but in marketing, perception is reality. What the client thinks is reality. Doesn't matter what you think. So what do? You phone the client, apologize, we sent flowers, we visited in a taxi, did all of that. Now, we may not get that purchaser when they sell, but we want to stop them bad-mouthing the firm. So those are some of the things you can think about. And you'll never make progress in this area unless you try things. You know, it's like this. Behold the turtle. He does not make progress unless he sticks out his neck. And that's what you have to do. You even have to think about things like paying partners for new business. Are quite a concept to grapple with now in law firms. In fact, in a newsletter that I do for Richard W called Law Practice Management, in the October '87 issue, there's an article by a U.S. management consultant that I had met, and I liked what he was talking about, and it is paying partners for new business. And if anybody of you are interested in that, that article is available. And you can use all kinds of service perks, what I call service perks, to market your law firms. Don't forget the importance of technology in trying to do this now. And what clients want, in fact, in my opinion, and how you build law firms and customer or client loyalty, is adding what I call value-added services. Because I don't want satisfied clients in my law firm. I want turned-on clients, because turned-on clients give me referrals. Satisfied clients, I might add, only pay their bills because that's all their obligation to you is. So you have to have turned-on clients. And the studies show that the vast majority of the people that we get and that the way you build a law firm is through referrals. In fact, I'm going to, no, I can't reach that. But if you, if I had time, I'd go through that, but I'm not going to have that time. And for example, technology. Here's a couple examples of the way that I would say you deliver value-added services. We make a promise to deliver our client a contract on the 15th. The client gets it on the 15th or the 17th. What you can do with a simple tracking system, I have one in my computer and I put VAS by those entries, called value-added services. What that's telling me to do, if I promise the contract on the 15th, I'm going to deliver it on the 13th. A service clients will pay for. Because what do they expect? And what was one of their needs? A timely service. If you deliver it ahead of time, it's value added. They will pay for it. You can't market a product of a service that you can't make a differentiation from your service and somebody else. What is it that makes you different from somebody else? Maybe it's that type of thing. Computers, for example, I love carrying my laptop computer with me. So age in Aurelia is an industry. Age in Aurelia is an industry. Many, many old age homes there. People cannot go out to law firms to see them. I understand that, and I market very heavily. I do it simply by having my laptop computer, a little printer in a briefcase. I go to the old age home with my 3 standard wills, pull it up, fill in the names, print it out, and sign it. At $125, am I too cheap? Is that, you get a will done here for that? Tell me so I can up my price. That's the type of things clients will pay for. To give you an example, I do that 2 weekends ago on a Saturday morning. I made an appointment to go see this very elderly, feeble lady, sat there with her, and she just loved it. But while she's doing it, 2 of her friends come by. I did wills for them. Was I supposed to ask whether they had lawyers? This is Osgood Hall, isn't it? I don't want to break any rules here. And there are many ways that you can make a difference in what you do. For example, ask people for work. You know, I was on a seminar about a year ago and the chief counsel of AVCO, who's been with them for 15 years, says they have 250 branches across Canada, and they get lawyers in the local towns like mine to deliver the service on the mortgages. In 15 years, that man never ever had one lawyer ask them for business. Lawyers have the attitude, if you don't succeed, to hell with it. And that's a great philosophy if you're a skydiver. Because one of the magazines that I read on a regular basis is called Sales and Marketing Management. And there are statistics published in there by Gallup or one of those organizations. They call it bird dogging. And 43% of salespeople make one call and quit. 25% make 2 calls and quit. 12% make 3 calls. 80% of all sales are made after the 5th call. So just because you've asked the local bank manager once, twice, 3 times, it's called bird dogging. When you fail on the 6th time, well, I don't know what you do then. You have to talk to a management consultant. But some of the things that, I'm going to end with this. Theodore Levitt, Dr. Levitt says that in order to market products and services, we've got to stop talking about products and services. We should talk about tangibles and intangibles. He says when you market tangibles, you always try successfully to market the intangibles. And many of us, as an example, have always said, you don't sell the steak, you sell the sizzle. Now, when it comes to intangibles, what does Dr. Levitt say? What is his advice to us? He says you've got to tangibilize the service. Make it tangible. Because you can't, as he would say, smell it, feel it. I mean, you can't try out a divorce. So what do? You tangibilize it. That's why, my friends, sending copies of the letters to the client is important. Now, lawyers argue with me and say, Milton, you wouldn't do that in a family practice because the clients call. What lawyers forget is the telephone is the cash register, if you set it up right. So I always go in and what do you get worried the most about? When the phone doesn't ring. So it's the cash register. So Dr. Levitt says that you try and do that. How do you do that? How we dress, how we articulate, how we deliver our services, how we package it, how we treat our clients, all of those things he calls metaphors and surrogates for reality. So you tangibilize it. And it's surprising, for example, how many people, if they see and lawyers in Ontario now, it's hard to meet a lawyer who say, holy jeez, we're busy. And I hear them saying that in front of clients. Surely you say, I'm busy, but I'm always looking for new opportunities. I just was at a bar association meeting and we had some clients there and everyone was complaining how busy they were. Amazing the clients, they'll think you're too busy and you're not taking referrals. Surrogates for reality. In my reception area, right, says, we appreciate and thank you for the opportunity of serving your legal needs. If you know of anyone as nice as you, please send them to us. What sort of culture do you have in your firm? I don't like that word culture. I can't spell it. What sort of atmosphere do you have? What sort of image do you have? How do you tell clients that you treat them? Everything that you do, you have to sort of instill that type of, you set a policy. No telephone call goes unanswered more than 12 hours in this law firm. I don't care what happens. Or policies like that. That speaks to clients' needs. Because if you looked at the 13,578 complaints last year to this law society, the vast majority of them was, I can't get a hold of my lawyer. He doesn't tell me what's happening. Market around that. So what is a client? Another famous sign that clients come and photograph and want photocopies of in my office, and it's a way of us trying to say to our staff, to us, tapping us on the shoulder, what's it all for? It's for clients. So it starts out, what is a client? A client is the most important person ever in this office, in person, by mail, by telephone, and it goes on. And I plagiarized it from the L.L. Bean store in Freeport, Maine. Because I learned a long time ago, being a bit of a writer, that if you copy from one person, it's called plagiarism. If you copy from 10, it's called research. If you copy from 100, it's scholarship. My stuff is scholarship level. But some of the things, I'm going to end on this very briefly. I know you want to get to coffee. And what the hell? Who's going to deny you coffee? I had mine at the Cooktown Turnoff, Alan, this morning, McDonald's there, right? Some of the things that are surrogates for reality, okay? Forms of marketing that we're all becoming familiar with. Brochures. Have some sort of a system for thanking people for referrals, for example. I mean, have a card. If I know how important referrals, so if I walk into a law firm and they say most of our clients come for referrals, I know how serious they are about marketing when I look around and say, how do you thank the people who refer? Clients. Have a little card. Put it on the desk. Make it happen automatically. I call it the toothbrush theory of management. You got to do it automatically. And I mean, I'm so serious about this stuff that my toothbrush is famous. You got to make it automatic. Make it easy for people. We've heard about newsletters. Show you examples of those, if any of you are interested. Some favorite ones of mine, for example, that we have one lawyer who does, and this is well known in our area, we have one lawyer who does criminal law, so we have a plastic business card, right? And on the back of it is how to talk to the police. There's not a high school kid in our area that doesn't have that. And the other thing you can use, what they tell me they use it for, because it's plastic, they can pick locks with it. So that's a marketing effort. Okay. Thanks for listening.
Thank you very much, Milton. We'll break for coffee now. We'll have a question period when we come back at 11:20, 11:25.